Yeah.
So I have multiple questions about this, but the 7,000 number, I mean, it's based on some worldwide number of people that they estimated were. So I'm curious, how much, once the government started sharing with you sort of these deals that were going on unbeknownst to you, did they share any kind of insight? For example, I mean, my understanding is that Germany may even still be paying reparations to the Israeli government, or at least did for many, many years. The Swiss cases after your cases for the, people who had everything from money to art stolen, the Austrian cases, et cetera. So your case really spurred, I think, a waterfall of these cases, which is a wonderful testament to what you did. But my question is, what was the 7,000 based on, and who is going to get it if there were the other constituencies that were eventually getting set up?
Okay, this is what I think.
It seems like such a low number for, you can never compensate it, but it almost seems like it adds insult to injury, even if it was based on something at the time.
This is what I think, this is what Professor Newborn told us. The survivors, most of these people weren't Jewish at all, so this is not like only about that. These were what were called slave laborers, people who were forced to work in Nazi munitions factories and didn't get salaries, and who live in various Eastern European countries. So all of those people, they figured out how many people they think there were. They had got all of German government and industry to put up $5 billion. They set aside a certain amount for property claims, and then the rest they divided by the number of claimants they thought there was going to be, and that's how they got that number.
What was the total pot?
Total pot, $5 billion.
$5 billion.
$5 billion. But I really do think that was the indirect result of this case. And all the governments before, that is, all the United States governments from the Truman administration up to the Clinton administration, didn't do anything even remotely like this.
Also, in addition, it was a condition by the German government that every single case open in any state of the United States, in any court, must be annexed to that treaty. Otherwise, they wouldn't pay for multiple reasons. It wasn't only the German government, it was also about 100 giant corporations, German industry corporations, who were to sign and to pay part of the $5 billion. So one of their main conditions were, we don't want any case left in any court. And so here comes the constitutionality of the annexing a case in a Supreme Court in a state, and without actually the client having his day in court. There's no doubt about it. It's unconstitutional. But that was a condition. Without it, there would be no payment at all by anybody.
Anyway, part of this executive agreement was that in any future case ever brought, the Justice Department, remember Ori Lev, junior grade Justice Department lawyer? The Justice Department would send a lawyer into the case to say, the United States government asserts the political question doctrine, and judge, you should dismiss this case for that reason alone. That's, by the way, why I thought we should take the settlement and give everybody $7,000 and take our chances with the IOM, because Judge Bassler, the U.S. District Judge in New Jersey, was threatening to do that. And I believed that he would. I didn't think that he was fooling around with us. I thought he would actually dismiss the case, and that would be the end of it. And we could take our appeal, and that he would be sustained. And I also thought that that the Justice Department did forum shopping, that this result was likely to happen. That was my view of it. And so that was why I thought we should do it, that it was not, at that point, a winning proposition. Well, it never was, but at that point, it really wasn't. So, yeah.
Did the estate get $7,000 along with the IRM and
the state, each of the estate,
remedy out of East Germany?
Yes, the estate of Ignatz got $7,000, and the estate of Ferdinand got $7,000, and we used it to print the record in the U.S. Court of Appeals in the Third Circuit.
The state got 30,000 Deutschmark, which is the equivalent of $15,000, and the lawyers got 722,000 Deutschmark, which is the equivalent of 360,000.
Please take a moment to write down lawline.com's second verification code. Lawline.com's second verification code is the word national, all in lowercase, N-A-T-I-O-N-A-L, national.
Yeah, which if Schutz had not gotten $5 million, we would have felt that this shouldn't happen this way. But Schutz did, so we were okay with it. Yeah.
You mentioned that all of these other cases, the class actions, were filed after you went to the Holocaust Museum. Could you speak a little bit more about what your theory is there?
Okay. I don't know what happened, but what I think happened is the rumor mill. After we went to 1996 and we met with the executive director of the Holocaust Museum and the director of the museum and the director of the library, there were 5 people as I remember. I mean, I don't think that they were quiet about that. I think that they told everybody that they knew. And that way the idea, entered into the public realm. Here's a question that I would ask me, is why didn't you seek publicity? Why didn't you go out and try and get, and the reason we didn't was, well, we thought we'd be laughed at. That was one of the main reasons. Another reason is there is a rule against it. You're not supposed to seek publicity when you have a case in court. Of course, that doesn't stop the client from seeking publicity. And Ronnie would talk to us from time to time about, well, should I seek publicity about this? But you have to think back to the way the world was in 1994, 1995, 1996, and that time. There were no other cases like this. This was thought of as wacky, not seeking justice. It was thought of as, what's wrong with these people? So we thought it would at least I thought it would backfire. That's what I told Ronnie.
What, if anything, what was the part of the bank? What did the bank ever take part in this $1 billion settlement? What did it cost the bank?
Yeah, we don't know, but we do know that every major German corporation and bank participated in this, of which there were how many? I don't know, but
100 corporations.
100, but they were the Nazis' bank, so I suspect they put up a significant amount of money. But that is nothing compared to what they stole. On the other hand, the United States Army and Air Force and Navy pretty much destroyed Germany. So, this cuts both ways. Yeah.
I'm curious about whether you think your model is applicable to some of the other reparations movements and cases that are starting to develop or have developed since this time.
Okay.
Or is the political doctrine just overwhelming in its opposition to all reparations cases?
Well,
that's my first question. And the second question is, Germany's now probably the largest creditor, one of the largest creditor nations. And I know that, for instance, many in Greece are now saying that they should just, refuse to pay the German debt back based upon the effect of World War II on Greece. And I'm wondering whether that you think there's a possibility that may arise as sort of a set-off argument in all of the debt issues that are going to come about with Germany now controlling the economic future of Europe as the largest creditor. So there's 2 separate questions there, really, so, whichever you want to answer, I guess.
Those are really good questions. Now, other reparations cases, I actually have had some experience with that. I did consult with the lawyers who brought the slavery reparations case. What we had that other cases don't have is Mr. Nacher saved the actual documents of seizure. We had the evidence of the actual theft. So that makes it a very different thing. Also, we had the victim of the actual theft alive at the time the case started, and then, now we're in the law of trusts and estates, we had his will, we had his estate, we had his executor. The law not only permits, but there's part of the Surrogates Court Procedure Act which says an executor is supposed to pursue all the claims of the estate and is not supposed to abandon the claims. They're supposed to pursue them for the benefit of the heirs, and if you don't, you can be surcharged. So, we were in a position of a reparations case where a procedural position where we had to do it, or at least the executor had to do it, and could be criticized if he didn't do it.
Now, we actually had 2 wills,
yeah.
Ignaz Nacher and Ferdinand Nacher.
Now, what happens if you have a reparations case with no will and no estate? I think and no evidence. That's not a good position to be in. So even though we had a creative argument around the statute of limitations, we had the big advantage of having the actual victim, having the actual paper trail, and having an open estate in 2 different surrogates courts. So that gave us a big advantage over all the other reparations cases. And so the other reparations cases, if you don't have that, I don't think you're in such good shape. Now, other people not paying German debt for money lent after World War II, after Germany becomes an economic power so many years later. I don't know. I think
it's weak, but that's what people are
well,
suggesting.
you know, if I were the judge of that, I would say, okay, look, if you can show me debt from 1934, maybe. But debt from after 1945, I don't know. You know, that I don't think. Because it all depends on time, place, circumstances, peculiar facts. You know, there's no general rule for this, I think. Yes?
I'm a little confused with the chronology here. When did you decide that you had to go to Germany to start that proceeding, rather than just, when Nachar died, just substitute his executor as the plaintiff in your case and just remain in state court?
Here's when we did, this was my own mental block. Professor Brown said to me, look, you got to get a lawyer in Germany. I said, I don't want to. Then it became apparent to me there were too many unanswered questions. Then we went to the German consulate. Then we got the reference of Sebastian Schutz. So I still, you know, I didn't think that any German was going to help us. I was completely in a, you know, I had my own mental block. So I wrote him a letter. You know, I faxed him a letter. We didn't have internet in those days. So I faxed him a letter, and I say, look, you were recommended by the German consulate. We want you to work on this case. You know, call me up. Well, he called me up and got on the next plane. He came to my office in Forest Hills. He came to Kennedy Airport, took a taxi cab. I mean, like that. I mean, I was, you know, kind of surprised by that. And we met with him, and we hired him on behalf of the estate. We hired him to help us gather evidence, and he told us that about the Laroff system and the fact that you could start parallel litigation, and maybe we ought to do it. And we said, okay, go ahead. You know, why not? We don't think our case is so great. Maybe you're going to have better luck than us, which turned out to be exactly what happened. So that's the way that happened. And also going to Germany. Yeah, I couldn't go. He wanted me to go. He begged me to come. I couldn't. To me, my own heritage is that Europe was just a graveyard. That's it. He didn't go there. It had nothing to do with it. But Yossi was born there, so for him it was a whole different thing. So he went. So that was a teamwork. You know, I went to the inside of American courtrooms, and he went to Europe. So that was very, very, very good. I mean, I wouldn't have had it any other way.
Why is art been treated differently than other property? For instance, you know, you can go and see the Klimt exhibit uptown, a beautiful exhibit, and I think that there actually been some returns to the family that owned all that stuff. And it seems like art, some of the art has been either returned or compensated even today. Are you familiar with any of the art?
I'm familiar with some of it from having read about it in the New York Times. All I can tell you is none of this happened before 1994, of which I am proud. What happens with art now? That's a good question, because the executive agreement that we were made a part of against our will provides no more litigation. What the Germans thought they were buying for $5 billion was what they called legal peace, in quotes, legal peace, that there would be no more lawsuits of any kind concerning the World War II period. That was their position. Now, that doesn't stop, you know, good American lawyers from figuring out, oh, well, this particular case is not covered by that executive agreement. I'm sure people do that. But there's not supposed to be. That was the idea.
Is it because some of the art is in private hands?
That's my guess. My guess is that those are private cases not involving Germany. That, you know, if an object of art winds up in some museum somewhere in Europe and somebody sues that museum, is that covered by this agreement? Probably not, because that's got to do with possession of a painting. It's not for compensation. It's a different kind of a case.
I hate to belabor it then, but why can't someone sue for an apartment building that's now owned by a, right?
Try. You know,
I don't know. It just seems strange.
You could try doing it, but you will wind up facing some junior grade lawyer from the Justice Department. That's a negative thing that came out of this case. Yes.
Excuse me. Have you guys been sought out now as authorities on these type of cases from others seeking reparation, particularly the Swiss cases?
Occasionally I'll get a telephone call, but no, because the executive agreement that they negotiated effectively ended this, which is unfortunate.
I get quite frequent calls about different nations, Romania, Hungary, Poland,